Well, we do know that Customs Department made a list of all of the people, religious entities, the lawyers, and others who were providing services to immigrants at the border, and was saying that they intended to rely on this statute to prosecute them. You're saying to me it didn't happen. Congress issued a subpoena to many of these organizations, did a lot of investigation as to what was said. So how do we tell all those people not to chill speech, because the only thing being punished under this statute, unless you want me to add that it has to say that the statute requires something more than just words, we're criminalizing words related to immigration. And I thought there were only certain statutes that were immune to First Amendment challenges. Obscenity, fighting words, otherwise everything else is subject to the First Amendment and strict scrutiny. So why should we uphold the statute that criminalizes words, makes the punishment 5 years, which is rather significant? I know of no other statute where aiding and abetting punishment or solicitation punishment is greater than the punishment we're giving the person who's going to commit the crime. But that's what we're doing with this statute. It's a first of a kind.
A couple thoughts, Justice Sotomayor. I think one of the traditional categories of speech that is outside the First Amendment is speech that, this is straight from Williams, is speech that seeks to induce or commence illegal activities. Our view is
if something is going to be illegal, but people enter the United States illegally all of the time, and they're here, they're remaining, but you would have to prove that they're remaining because of those words. Are you willing to take that part of the element? Because that would make sense to me.
We're willing to take all of the soil that comes with the idea
of
aiding and abetting and solicitation. So do you believe that the
soil includes that the government has to prove that the words actually is what caused that person to remain?
No, I don't think that's a requirement of traditional.
So why not? Because that's what I think words that have to do with inducing a crime is, that you want the crime to succeed and that you have to make yourself a part of the principle of succeeding in that crime.
So if that's what you think aiding and abetting connotes, then that's actually a further reason not to hold this statute invalid as overbroad. It means the statute has an even narrower
Well, no, you
range.
tell me, because I think we're going to talk to the grandmother who lives with her family who's illegal or who are non-citizens. The grandmother tells her son she's worried about the burden she's putting on the family. And the son says, Abuelita, you are never a burden to us. If you want to live here, continue living here with us, your grandchildren love having you. Can you prosecute this? And if not, why not? So what do you tell the grandmother?
I think not, Justice Sotomayor. I think it's very hard to make out.
Stop qualifying with think. Because the minute you start qualifying with think, then you're rendering asunder the First Amendment. People have to know what they can talk about. Once you create a lack of clarity in the law, then we're not writing to clarify it.
Justice Sotomayor, I don't think it's possible for me or for this court to define how these principles will apply in all of the different factual circumstances that we can imagine, and I think the fact that we're trying to engage in that exercise is one of the problems with overbreadth analysis. What we would do is have this court say, not the government say, but this court say and write into law the idea.
You could ask to criminalize actions, not words. You've chosen to read a statute that criminalizes words. Shouldn't we be careful before we uphold that kind of statute?
We're asking you to go only so far as every aiding and abetting and solicitation statute goes, and to criminalize words.
Well, generally with aiding and abetting, the person has to do something to make that act come about.
I think generally, yes. I think there are some circumstances where soliciting someone to commit a crime with words would count, and I'm not willing to give that up here because our position is the same aiding and abetting principles ought to apply in both contexts. But if you have a narrower conception of aiding and abetting, that is only all the more reason to conclude that this is a narrow statute that doesn't trench on the First Amendment.
Can I ask I'm sorry.
Go ahead.
There was an intent requirement asked for here. You say it was broader than you think it should have been given. But we've had a number of cases this term, Criminelli, Percoco, Dubin, now this case, where the government is conceding that the statute read by its plain terms is too broad. And you come back to us and say, read it more narrowly, but you won at a jury trial on a broader charge. If we keep doing as you ask us to, which is to rewriting statutes, are we encouraging the government to continue this practice?
I don't think so, Justice Sotomayor. And again, we're not asking you to rewrite the statute. We're asking you to give these words the same meaning they have.
You said the jury instruction wasn't consistent with this.
So that's right, Justice Sotomayor.
And in those other 4 cases, it wasn't consistent with this. You keep coming here and admitting that statutes have to be read in a different way when you argued the opposite below.
So let me put this case in context, Justice Sotomayor. This case was tried before Sinning Smith came up, before the Ninth Circuit called for supplemental briefing on overbreadth, and it really injected this whole constellation of issues and concerns about a broad reading of the statute that didn't really exist before. And at the time, I think it was reasonable for the government to support the model jury instruction, especially because no one seriously argues that the speech at issue, the conduct really at issue here, was protected by the First Amendment. So I acknowledge we didn't write the instructions at the time of the trial the way that we would write them now, with the benefit of 5 or 6 years of experience and a lot more airing out of the arguments. And I acknowledge you should send the case back to the Ninth Circuit and let the Ninth Circuit decide what's appropriate in light of that.